Thank you, members. Welcome to the Planning Committee for Friday the 11th of October. I have two apologies from Ken Smith, who is poorly, and Andrew Hart, who is, I think, having some operational procedure in the hospital. Are there any other apologies? Do we know of them? No? Okay. The minutes of the previous meeting held on the 13th of September, I'm happy to move those as a correct record. Is that seconded? Are there any comments on the accuracy of the minutes? Bill?
Yeah, just a few typos that something refers to page 8, the second line from the bottom, it says meal time, which is a nice idea. It should be mean time, I think. And then there's another on page 10, in the resolution on point 3, it says secure finish of the school to make it dark. It should be it, I think. There's no S on that. And the only other comment I had was on the very final paragraph, which was talking about the top Riley Lane. I did make the comment that the inspectors thought there was no transport or vehicle movement issues, and I think I said that I was very surprised they made that comment, because I thought it was significant, really, that there were significant vehicle movements there, which I couldn't understand how the inspector had reached that conclusion, bearing in mind the importance of the site for people visiting Eyam and visiting the historic the Riley graves, which virtually everyone would have to do on foot, because there's no other way of getting there. So I don't know whether that's worth putting in. It has relevance to other, a wider relevance as well. Yeah.
Well, we don't want to reopen the debate. Can I take the first two issues first? Those are typo issues, which we can accept, I think, as part of the minutes. I'm happy to take a view from officers on the point that Bill was making. I think our general view is that comments from individual members don't get put into the minutes. Is that right? Is there an issue here?
It's just a summary of the decision that goes in. We could include it if members specifically want it to be, but generally we wouldn't.
You would have that on.
Sorry. Yes, generally the minutes are a summary, so we wouldn't usually include every specific comment that's made, but if members want that to be included, we can do. If you think it's relevant and would want to be included, we can make an amendment.
Well, in the interest of progress, can we include a sentence to that effect?
Yes.
I don't think it'll get us anywhere, if I can put it that way around. But I don't think we want to fall out over it. So subject to those amendments, all those in favour of adopting the minutes? Anyone against? That is carried. Abstention, sorry, one abstention, that's fine. Urgent business, I have no urgent business. Public participation will occur as we go through. Declarations of interest, any members have any interest to declare? Ginny?
Yeah, I've had an email from the agent for the first application, James Darwent, which I have forwarded to members, and to Brian and the Planning Authority.
Thank you very much. Kath?
I think you know mine because I've discussed it with you, Patrick, but I was concerned the fact that I make hundreds and hundreds of pounds of jam, which I'm relying on the bees to supply me with help. So I asked if I needed to declare an interest, and Patrick said no. Okay.
And Michael?
Simply that item 7 is an application from our own Park Authority, of which we are all members.
Yes. So, Okay. That's dealing with public declarations of interest. So we're on to agenda item 6, which is the proposed creation of an agricultural barn for beekeeping, etc., at Swallow's Nest, Eyam. Who's presenting this? You, John?
Myself, Chair. Thank you. Good morning, everybody. This is the application site on the screen at the moment. The area edge red is the application site, and the blue is other land in the applicant's ownership. The site is Swallow Nest Barn, which is a converted, presumably a former bothy that sits within the walled garden area to the principal listed building, the Firs. Now, you can see on the screen, this is the Firs, the Grade 2 listed building. There is a walled garden around that to the rear, and in the corner of that was this former bothy garden horticultural building, which was converted with members' consent back in 2013 to a dwelling, subject to strict conditions to control curtilage, design, as you would expect to respect the heritage asset, as a curtilage listed building, along with the wall. The walled garden is a curtilage structure to the principal listed building. The dwelling straddles this tall wall we'll see on the slide partly, and there is a parking area and turning area to the rear associated with the new dwelling, and the driveway back up to Edge Road, which leads out of Eam up towards the Bowlin Breton direction. So the site lies within the open countryside to the north of the village of Eam for planning purposes, and it also lies within the Eam conservation area. So the proposal is for the new building sited here. You see the small square there is an existing timber shed we'll see on the photographs, which would be removed, and in its place the proposal is for a 9 by 5 metre agricultural building in connection with the applicant's business of beekeeping. The building is needed for the processing of honey and other associated activities with breeding of bees, keeping of bees, and the maintenance and construction and sale of hives in addition, along with candles from the beeswax. They currently run the business from the home. It's successful and they need some space to expand into, and the existing timber shed is no longer suitable for their purposes. The next slide shows the location of the new building, which is here, and an aerial shot shows the site. So this is the dwelling that straddles the listed wall, the parking area, the lighter colour, rising hillside, the existing timber shed, and slides showing, for context, this is looking down the driveway from the Edge Road. So you've got the dwelling here, the existing shed and parking area, and close to. So this is the end of the parking area where you go through into the field. This is the existing shed. It was unauthorised, but it's been there for some time now and has acquired immunity from any action. And you can see it's quite small and it's no longer sufficiently sized for the applicant's purposes. Just looking back a little bit more context, see the rising ground. And this one shows more the context to the back of the house, which is a lean-to on this side of the tall curtilage garden wall. And this point here, you can see how we saw on site yesterday how the wall has fallen down in this section. There is a small area of hard standing here, and the ground rises. So, as existing, that layout, I should say on here it does show that all this to be curtilage to the house, but the approved curtilage, members will remember, was granted to be very tight to this area here, so there has been an expansion of the residential curtilage and the incorporation of this new greenhouse into the curtilage. But that's a separate matter to the matter in hand today. So, as proposed, the existing shed is removed and the new building would sit here. Because of the rising ground, it would require some excavation and a new retaining wall at the rear. And you'll see there some additional planting being proposed to screen the building in the wider landscape. What you won't see there is the detailed wording, but there's an area, different rooms for the extraction of the honey, the processing of it, the drying of it, bee breeding, etc., and hive maintenance workshop and storage on the right-hand side. Elevationally, that's the existing shed from the parking area, the proposed new building, which would be, as I say, 9 by 5 metres, and it would be 4 metres high overall. It would be clad, as you can see there, in vertical timber, and would have an anthracite grey, sort of dark grey coloured zinc or aluminium cladding roof. The windows and doors there would be, again, anthracite grey, recessed aluminium windows, and the vertical doors and shutters there would be, again, timber. Existing from the rear and the new building. What you don't see here is actually be set into the rising ground, so that dotted line here is the ground level. So viewed from Edge Road, you would see the roof and part of the back of the building. And again, just the other elevation and as proposed. So since the report was drafted, we've had further discussions with the agent, clarifying the status of both the existing shed, which I've talked about, and regarding the proposed use of the building. And we also heard on the site inspection yesterday from the applicant himself about how the building would be used. And it's clear that the vast majority of the building would be used for agricultural purposes. So we are satisfied that there is an agricultural need for a building, and it is sized accordingly. There would be some business use, making of hives and selling to other beekeepers, but that would be ancillary to the main agricultural use and a form of farm diversification effectively. Therefore, the main policy which allows for the principle of a building like this is our agricultural policy DME1. So in terms of our recommendation, I would like to change that. So I'll give you the altered wording. So rather than reason 1 being an objection on the grounds of a business use solely in the open countryside, we would refer that to be the proposed agricultural building would be contrary to DME1, and I'll talk a little bit further about the reason, but the main reason is it would be contrary to that because it wouldn't be well related to or making best use of the existing walls and other landscape features, and thereby not making use of the least obtrusive or otherwise damaging possible
very
location.
clearly. Could you just start that sentence again? I didn't quite hear what you were saying.
Yes, so the revised wording would be the proposed agricultural building would be contrary to policy DME 1B, 1 and 4 to be precise, and cause harm to the landscape setting by not being well related to and making best use of existing walls and other landscape features, and thereby not making use of the least obtrusive or other damaging possible location. Effectively picking up the wording from policy DME1, which you have before you. And the second reason for refusal remains because our second objection is the positioning and form of the building is causing harm to the setting of the heritage assets here, the listed garden wall and the listed outbuilding to the principal listed building, and also being sited within the conservation area causes harm to the significance and setting of that conservation area through its siting. So in this case, no objections to the principle of an agricultural building. It's primarily to its impact on landscape and the setting of those heritage assets, which we saw on site yesterday, Chair. And so for those reasons, the officer recommendation remains one of refusal. Thank you.
Thank you very much. Right, we have one speaker, Mr. Darwent. You've been before, haven't you? You know what to do. Okay, you have 3 minutes to address us. Thank you.
Okay, good morning. Our client established Hope Valley Honey in Eyam in 2019. Mark is a 4th generation farmer and is now a very passionate beekeeper with his wife. Hopefully yesterday on your visit you learnt a little more about beekeeping, husbandry and the processing of the honey. They currently own and run over 50 hives, which is growing steadily due to the demand of their products. The hives are spread widely across the Hope Valley, including a Peak Park rewilding site at Stoke Hall Quarry. The existing shed, I think I can sort of skip some of this now because obviously John's changed some approach on this. I think that is now obviously deemed lawful, and it really seems to be about the siting of the proposals. However, the decision. Sorry, just 2 seconds. Let me, because my speech has changed somewhat. I'm based on this. So we're all agreed that beekeeping is an agricultural activity, and the part in question is the processing, which is the very end of the of this thing, the process. And the building is now agricultural and not a Class E business use. So I think it is just about those points. Through the process to date, the planners have not engaged with us at all on the design of the shed, which is to us a simple traditional massing in the form of a modern agricultural timber-clad shed seen widely across the national park, which is usually deemed acceptable for other farming activities such as storage of agricultural machinery or for keeping of animals. A stone or natural slate would be economically unviable for the business to achieve. He's probably asking too much of our clients. The shed positioning, as you'll have seen yesterday, is set into the bankside with a good amount of screening, and there is a sort of a yard almost between the listed wall and the shed, which is very important because that's where the building takes place outside as well as sort of within the building. So we think that the relation to the existing buildings works well. The screening to the top will sort of screen it in and set into the hillside. So we hope you'll support us. Hope Valley Honey is a family-run business with a good local customer base that needs a little support for this growing section of the farming industry. Thank you for your time.
Thank you very much. Right. I'm struggling a little bit with this because the whole basis upon which we were reading a report to refuse it has suddenly changed, because it was starting off with a sort of an absolute, this is a business in the open countryside and you can't have it, to this is something suitable in the open countryside, but this is not quite right at the moment. And we've just been hearing from Mr. Darwin that we've not had very much discussion. When the issue is you can't have it, there won't be much discussion. When the issue is you can have it, but you've got it wrong, then there's room for discussion. And has that discussion taken place? It's not, has it?
It hasn't, because we've only recently, obviously in the last day, heard those details and clarified that position. So it's something that we would otherwise have gone down and had much more extensive discussions with the agent, for sure.
Because, I mean, whether this is the right location or not, there are other unanswered questions. For example, the application boundary includes an area of, which plan? You haven't got one on the plan. I've got a plan here showing the siting of the building, but there's a piece of land that goes beyond that, which would, as it were, form another yard attached to the building, and we don't know how that's going to be used, do we? I'm opening it to members. I'm just going to say I'm not sure that I feel able to make a decision at the moment, but let's have a look what the members may wish to say. Mike.
Chair, just in answer to your last question, I would have thought on dry days the yard would be used for doing construction work and cleaning work on the and other such associated activities with the hives, which you probably wouldn't do on a rainy day. So, I mean, that bit seems clear to me. It's just the way sort of with that kind of work it would spill out of the proposed agricultural building. The only concern I had really was why the building couldn't have been moved a little bit further in, so that some screening could be put down the near side, which can be viewed from the road. Whereas basically it's screening from the road as it goes above the shed. But I didn't have a problem with the size of the building.
Take a point of time. Other members? No? So we've got Bill, then Matt.
Yeah, just a few. I mean, it sounds like there's more work to be done here, but I mean, the applicants are clearly enterprising and has developed a viable business, and I'm sure that we want to support that. However, I was just looking at the history of the site, which I think is quite relevant, is that the site changed only quite recently, and the drive and the use of the building as a residential building only happened in 2013, approved by the planning committee against officer recommendation, as I understand it. And I think sort of moving forward to looking at this, I mean, it's very apparent that there's lots of sort of unauthorised and unauthorised uses of the residential uses extended into the fields, and I know this area quite well. I've taken school groups along that road. It's quite an important place in the village of Eyam, which itself is very important. As you walk up the road to Mompesson as well, again, that's I mentioned in the previous comment that it's a really important road. That it's not just a rural road in the Peak District. It gives foot access to Mompesson as well, and the moors and woodlands and other areas beyond that. So I think we need to think very carefully about the development and the impact on the site, and any proposals on the site needs to delineate exactly where any commercial use, any industrial commercial use is, and that should also be defined by planting, more extensive planting than is shown there, because there is quite a large parking area which I think could be used for assembly of boxes and parking and loading and storage. And we've seen the effects of storage in an area when we went to Wild Boar Clough, for instance. So, if members who went on that visit can remember. There are heritage features nearby. The landscape is very important. And there's perhaps more discussions could be had about the materials. So, that's my views really. It's quite a sensitive site, and perhaps more work can be done here.
Matt.
Yeah, it was a question about when we decided to change the reasons for refusal, because that is quite a significant change. In principle, I have zero problem with this but I can see that there are obviously issues with detail, and I would support us deferring it, but coming back as quickly as possible, because I think it's a reasonable application. It's a reasonable suggestion, but there needs to we need to have more conversations about what the materials and exact siting and stuff like that. But
Are you happy to move that?
Sure.
Yeah, okay. Is that seconded? Any other members wish to comment? In that case, can we proceed on that basis? Is there any reason why we shouldn't?
No, I think that's a perfectly valid one. It enables us to have a very constructive conversation with the agent and achieve an outcome that suits both parties. Thank you.
Ginny?
Thank you, Chairman. If we're going to defer it, can we defer it on the basis that we accept the need for the building in principle, and for deferring it just to improve on the siting and the design?
Yes, I mean, I'm happy to defer it on the basis that if the officers and the applicant can make a decision, they should be able to get the decision. It comes back to us if they can't. Does that make sense? Yeah. Okay. Well, on that basis, all those in favour of deferring? Anyone against? That is carried unanimously. Okay, thank you very much. You understand the point you're making?
Yes, so essentially, if we can come to an agreement with
Yeah.
the detail and the citing with John and Chris, then they can make a delegated decision.
Yes.
Essentially without coming back.
I think we're looking for some certainty, not just with this application, but for the future as to how this thing is going to develop. One could see it growing like topsy if we're not very careful. As Bill said, it's a very sensitive site, so we've got to take that on board. Okay, thank you very much indeed. We'll move on now to the next application, if I can find it. Knowle House Farm, Reapsmore, agenda item 7. Application by ourselves. No speakers? No. Right. Would you like to introduce it, please, Adam?
Thank you, Chair. Keep this one brief. It's a relatively straightforward application. It's come to committee because the authority is the applicant. This is part of the Warslow estate, this farm. It's between Longner and Wardslow. I think committee on site visit a few months ago probably passed this site. But the farm is here and the agricultural building is here. And yeah, so quick close in, you can see the building. That's the view from the road, and the building we're looking at is this portal frame building here to the rear. And this is the side elevation, which is going to be altered. It's a cattle shed. There's currently some asbestos sheeting, which obviously the authority has to deal with and replace with more appropriate materials. So there's going to be Yorkshire boarding to this side, and then on this side, again, asbestos sheeting is being removed, replaced with metal cladding, metal sheeting. So they're the two elevations that are affected. That's the floor plan of the building, which isn't changed. So this is the existing side elevation with asbestos sheeting on the top there. And it's just a bit of a spot the difference. That's what's proposed. So that's brought down to this level with Yorkshire boarding. And then on the gable that we've just seen, the asbestos sheeting's up here. And that will be changed to fibre cement sheets. Sorry, I said metal before. It's fibre cement sheeting brought down to a lower level. So improves the appearance of the building. The building is in use for agricultural purposes. The proposals are clearly necessary to remove the asbestos and would result in enhancements to the appearance of the building. So officers are recommending for approval. Thank you, Chair.
Thank you very much. Seems straightforward to me.
Chair, was this the one we went to on
It
the
is,
annual
yes.
tour
Yes.
last year?
Yes.
Yeah, thanks. For those of us who were on the annual.
I'm happy to move this from the chair. I don't know, but it was seconded. Sorry?
I just have a question about the choice of materials, because you've mentioned cement boarding and York boarding. I don't know the difference, but just thinking about how sustainable those materials are and why we've gone for cement when it's a highly carbon emitting material is just my question. Thanks.
No, it's a good question. I mean, the applicant isn't here, unfortunately, so I don't know why the property team has picked that material particularly. Yorkshire boarding is just timber boarding. That's sustainable. But yeah, you're right, fibre cement uses cement, which is carbon emitting. It is a common material used in agricultural buildings. I can't answer the question on particularly why there's a functional requirement for that to go on this elevation. So I can't give you any more answer to that.
It's usually used to make sure that if animals and things kick and shove and pieces of machinery hit it and things like that, there's less damage than if it's just boarding. Yes, it's robust. But we are gradually trying to make sure that the Yorkshire boarding comes much further down than it has been doing. Okay, well, I'm moving it from the chair. Is everybody prepared to second it? That's Ginny. Is anybody else got anything to say on the subject? In that case, all those in favour of approving it? Anyone against? That's carried unanimously. Oh, one more abstention, sorry. Abstention. Two abstentions, sorry. Okay. Must keep my eyes open. Right. And what about are you dealing with the monitoring report?
Andrew's probably scarping downstairs.
Okay.
So we'll report that back to them.
Yeah. Okay. We're just waiting for Andrew Cook so that we can deal with the monitoring and enforcement report. What's the thing about? The governors were agreed to get rid of.
changes I think have been resolved, because it just sits on the template, nobody's thought of it.
Sorry to keep you waiting.
Right, Andrew, we have your report in front of us. We haven't approved it yet.
Yeah, thanks very much, Chair, and apologies again. I knew you were going to be quite quick through the agenda, but not quite as quick as you've been, so caught me on the hop there. Okay, nothing really to add to the report other than just to draw your attention to paragraph 6 under the heading of performance measures. So arising out of a couple of things, as the report says, we had an audit, internal audit process about a year ago, and one of the actions coming out of that was to look at how we measure our performance. So we've been looking at that both in terms of how we do that internally as managers, but also how we report information as part of the quarterly report. So what we've said is that we will, as you'll see in paragraph 6, the main two issues that we've picked up from discussions with the Chair and the Vice Chair recently is that the main issues are the number of cases that remain unresolved for a long time, and we appreciate there are a number of those, even though we are reducing the backlog quite significantly. There's still a number of cases that have been around for a long time and longer than we would like, certainly. So there's those, and then there's also some cases that will fall in that bracket, but also other cases where we've served an enforcement notice already. So we've made that decision to take enforcement action. The notice has come into effect, so there might have been an appeal or not, but the process has been gone through, the notice has come into effect, but the requirements of the notice have not been complied with, so it's still an outstanding matter. The enforcement notice has not been complied with, and there are a number of those cases that we still have on the books, and I think the concern is that we're not taking timely action on those, and I think we have to admit that that's not happened certainly in the past, and we are trying to improve on that. So those two measures are things that we can, those two figures if you like, on those two measures we can bring to committee. We're suggesting that that is done as part of the annual review, which is brought to committee in April. So we would propose to include those figures and information on those in that report in April of next year, and in subsequent annual reports. There is just one correction I need to make in the list of resolved cases. And that is, I haven't actually got page numbers unfortunately, but let me just find the one. It's not quite sure how to direct you to this one, but it's quite near the start of the list of breaches resolved in paragraph 11. It's about the 10th case down, which is Orchard Farm, Monsdale Lane, Parwich, case number 22/0003. You'll see that the description of the breach and the reason for the completion of the case is exactly the same as the case underneath. And that's a mistake. It's the Orchard Farm one was actually a fence, not a yurt. So it's erection of a fence, and the fence has been removed. So I just wanted to correct that case. So in terms of the report itself, obviously I'm happy to take any questions or comments, but before that, if I just run through the photographs that we have, that we normally show at this time as part of this report. So these are cases where that appear on that list of cases that have been resolved. So this will be one that's hopefully quite familiar to this committee. This is the land at Cresbrook, where we've taken 2 lots of direct action. Firstly, in December of last year, we removed a teepee and a parking area, and I showed some photographs of that to a previous committee meeting. And then more recently, we've removed these steps that were constructed on the land. And that shows the result of the steps having been removed. That work was carried out in July, I think it was, this year. So that case is now closed because all of the breaches have been resolved. This is a site up at Tintwistle. This is a site where we issued an enforcement notice, and in this case the enforcement notice has been complied with. So it was the siting of the container which was used for storage of bottles of chili sauce and similar in connection with the owner's business. But that's now been removed. That photograph shows the van is parked where the container was. The owners have actually erected a building within the garden as an alternative to the container. So that's a good result really for us, and hopefully a good result for them as well, because they've got a proper building now. This is up at Bradfield, Foxholes Farm. Construction of a platform. That photograph isn't particularly clear because it's taken into the sun, but hopefully you can see that it's been dismantled and it has now been completely removed from the site, I believe.
Is that the place where all the weddings were happening?
Yeah, I think
yeah.
I think the platform was used as a base for the marquee. And then this is over at Pike Hall, Millinglow Grange.
Oh yes,
Shepherd's huts that were sited on the land.
no, I've seen that.
Yeah. Now they've been removed. No, that wasn't an enforcement notice in that case, no. This is within the curtilage of a listed building. It's a relatively modest shed, but because it's within the curtilage of a listed building, obviously it's more of an issue for us. Metal, I think it's a metal shed, not too sure. Certainly got a metal roof, but that's now been removed. And I think this is the last one, might be one more after this. This is over near Cornford, right out in the open countryside, a caravan and shed that were on a piece of land there. And again, they've been removed. Yeah, that's the last one. As I say, if there are any questions or comments on the report, I'd be happy to try and respond to those. Thank you.
Right, Mike, let's just take a list first of all. We've got Mike, Kath, Matt, Bill. That'll keep us going for the moment. Right, Mike.
Thanks, Chair, and thank you, Andrew, for this report. I find them really helpful in giving us an idea of what we're having to deal with in the national park to protect it. And I'm currently attempting to get my own authority to raise the profile of the enforcement work that's done within Sheffield. So I thank you for that. I'm just a bit unclear about when the reason given is it's not expedient to take enforcement action on buildings. Is that due to time lapse or to because it permitted development?
It's merit.
Yeah, as Patrick said, it's the merits of the development. So when we have a breach of planning control, we have to make a decision. If we're coming to look at whether we should take enforcement action or not, then we have to consider whether it's expedient to do that. So there has to be some harm, some significant harm that's being caused by the development. So it's much like a decision that you'd make on a planning application. You'd look at the relevant policies and so on. And if we conclude that it's not got any particular harm and it's not in conflict with the policies, then we make that decision that it's not expedient to take enforcement action.
Can I just say, I do hope you're not very successful in getting your enforcement sorted out in Sheffield, because we may end up with all our enforcement officers going there. Kath?
Well, I just wanted to say one more thing. It's since I've been on this authority since 2018, you're still, and it must be very frustrating for you as it is for others. The tracks that have been laid down for some time now in the Sheffield area, and trying to get enforcement action. And it's a shame that we're at that historic England don't seem to see it the way we do, as sort of being natural England, as being responsible for the national park.
Yeah.
But you certainly have my full support.
Kath?
Thank you, Chair. Page 35 and the third application down, Cordwell's Mill. It's very frustrating for local people. They really would like something done with this building. Is there any further update other than what you've put, installation of internal petition wall?
To be honest, I don't know what's happening with it. What is it empty at the moment?
Well, it's not used. It's got a huge block in front of it. You can't even get into the area. It's been there for several years now.
Right. Okay. I don't know if we have another case on that. Is that do you think an unauthorised development then?
Isn't it something you can take up with
I don't know. It's been there for years, and the mill has been closed 2 or 3 years now, and we don't hear anything. What is happening? I just wondered if you had any extra information as to whether it would reopen or not.
Kath, I think it's with the Haddon Estates, isn't it? Yeah. Brian's just made a note. They'll see, make a few inquiries and see where it's going. Okay. Can I move on to Matt?
Yeah, it's following up with Mike's point actually about the tracks. The first one, the Mickleden Edge one, was happening when I worked at the National Park Authority, which finished in 2018, and we'd been working on it for 2 or 3 years at that point. That's a really long time for some serious development within the most protected bit of the national park. Have you got an update on what's happening?
This is the Mickleden Edge Midhope Moor case. Yeah. As it says there, we're currently waiting for an appeal decision against the Natural England consent. The landowner appealed against the conditions of that consent, so we're currently waiting for that decision. And the advice that we've had internally is that we wouldn't be successful in pursuing a prosecution for non-compliance with the enforcement notice whilst that appeal decision is awaited.
Okay.
But surely the two things are separate. It's in breach of the habitat regulation. So Natural England shouldn't give consent for it from that point of view. But actually, it's not got any planning permission. So if Natural England say yes, that it is okay in terms of the habitat regulations and the impact on the SSI and SAC, that doesn't actually mean that we would then automatically give it planning permission. So the two things are completely separate.
Sorry, I should make it clear. The consent from that's been gained from Natural England is for removal of the track. So it's to comply with the enforcement notice, essentially. So it's not that they've applied to Natural England for consent to retain the track. So that's why it's relevant to the enforcement notice. And that's the advice that we've had internally. So, we obviously must take that advice.
Balmy, isn't it? It's absolutely balmy. There we are. Bill.
Yeah, just briefly. First of all, thanks for your report. And I thought I'm a big fan of before and after photos, and I thought they're really helpful. So more of those, because I think it gives a really quick snapshot of what's been happening and how things are. So thank you very much for those. I look forward to the next before and after shots, because I think they're really good. And then, I was going to ask the question about not expedient to take enforcement action as well. So thank you for your answer. And I guess that they're things that you just leave, but I guess things where you're happy with the development, but conditions on a potential application would be helpful. You ask for a planning as a sort of another stage. You ask for a planning application, which you're going to grant probably, but you're able to put conditions on. So I suppose that's the other step that you can take as well, isn't it? Yeah.
Yeah, absolutely. Yeah.
Okay, and I've got Ginny next.
Yes, thank you, Andrew, for a really good report. It goes back to one of the points you made earlier, where it's not expedient to take action. And this is something that's left. Somebody might have done something where they've not had any planning permission for, and we don't take any action. How does that stand in law then? By not taking any action, have they got planning permission by default, or should they actually put in retrospective planning application?
Yeah, it's a good question. I mean, even in those, no, the answer is no. They don't. It doesn't mean that they have planning permission for it. It's still an authorised development. So we do actually still encourage people to make an application to regularise it, because clearly, if they were to sell the property, for example, it could be raised as an issue that could affect the sale, for example. So we do still encourage people to submit an application, even where we consider it's not expedient to take enforcement action. But clearly, after a certain period of time anyway, it would become immune from enforcement action after now a period of 10 years. So, but, the requirement to consider expediency is in the legislation itself. It's in the 1990 Act. So it's something that we're required to do when we're considering whether to take enforcement action or not. Hope that helps.
Okay, and all of you have missed the most important point about the report, which is paragraph 6. Up to now, our reports have been in the form which you can see in paragraph 10, where we have been, the only statistic, as it were, that we've been given is the ins and outs. How many complaints are coming in, how many are being dealt with, and how many are outstanding. And as we know from recent times, there have become a number of cases, some of which we're now seeing coming up on this list, that are being taken out of the list because they've been outstanding for too long. And what the officers are looking at all sorts of permutations of different targets and various other things of that sort, which will help them keep a better eye on things in the future. But I've been pressing for us to have at least annually a report which tells us about the number of outstanding cases and for how long they've been outstanding. So that I think is a must for the future, and that would come up in the annual report. I do think, though, that, and I haven't had a chance to discuss it with Andrew, but I briefly discussed it with Adam. I do think, though, that once an enforcement notice is in place, if it's not been complied with within, say, 3 months, I think it ought to appear in our priority list that comes before this committee. Does that make sense? With a brief explanation as to what's going on? And then we'll see how we get on with that. And I think if other members have a thought about what is or is not a high priority case for appearing in that list, I think it would be useful to think about that, and maybe as we get this report periodically, we can add to the criteria for what are priority cases. Having said which, where are we up to with Home Farm Sheldon?
I have to be quite careful here in what I say because obviously we're contemplating potential legal action.
I'm very happy to leave it for later on in that case, if that would help you.
Yeah, okay, I'll say no more then.
Okay. Well, on the basis that this is a report primarily to note and to put in place the monitoring system, I'm going to move the recommendation on the basis that I've just outlined, that in future, outstanding enforcement cases of over 3 months become priority cases for reporting. On that basis, I'm moving this report for approval. Anybody?
Sorry, you just said enforcement cases. I think you meant enforcement notices.
Enforcement notices, yes. And you're seconding that, Mike, right? Has anybody got any further comments on this report? In that case, on that basis, all those in favour? Anyone against? That is carried. And can we then move on to agenda item 9? Now, we're not allowed to discuss this, otherwise I shall have to get a resolution to go past 11 o'clock. Appeals lodged, a straightforward list, and no appeals decided on this list. To note the report, all those in favour? Anyone against? That is carried. And that concludes the meeting at 6 minutes to 11. That's never happened before.